This is a measure that prohibits carrying guns at several locations around the county.
Restricts the possession and transportation of firearms within 100 yards of places.
New gun law that restricts ghost guns and creates a 100-yard buffer zone.
DOJ as it sues Montgomery County over its new gun control legislation.
New law is effectively put most of the county off limits for law-abiding citizens.
In the quiet suburbs of Montgomery County, Maryland, a startling shift in legal reality has transformed ordinary life into a potential minefield for thousands of licensed gun owners. If you were to walk out of your front door today, permit in hand, you might believe you're acting fully within the law. However, a series of legislative maneuvers, most recently codified in Bill 23-26E, has created an environment so restrictive that it has drawn the immediate aggressive intervention of the United States Department of Justice. This isn't merely about policy disagreements. It is about a fundamental collision between local ordinances and the constitutional protections of the Second Amendment, creating a situation where simply visiting a local library or walking past a public park can, in the eyes of the county, turn a law-abiding citizen into a criminal in the blink of an eye.
It is just the latest lawsuit hitting the county, already grappling with a budget shortfall.
Whether guns should be allowed in certain public places, specifically houses of worship.
The root of this massive legal controversy lies in the implementation of sensitive areas and the implementation of a sweeping 100-yard exclusion zone around them. When the Montgomery County Council, supported by County Executive Marc Elrich, moved to modernize their firearm regulations following recent state-level judicial rulings, they cast a wide net. Under the new guidelines, carrying a firearm within 100 yards of any designated place of public assembly, a category that includes parks, houses of worship, libraries, recreational facilities, polling places, and courthouses, is strictly prohibited. What sounds like a simple logical safety measure on the floor of a council meeting becomes a mathematical impossibility when mapped out across a dense suburban landscape. To understand the sheer scale of this, one must look at the geometry. Montgomery County is a patchwork of public infrastructure, private businesses, and community hubs. When planners applied a 100-yard buffer to every school, park, and library, those zones did not remain neat, isolated circles. Instead, they expanded outward like hundreds of overlapping ink blots, eventually merging to cover almost the entirety of major residential and commercial districts. Areas like Bethesda, Silver Spring, Wheaton, and Rockville are effectively blanketed by these exclusion zones. A person driving on a major artery like Interstate 270 or the Capital Beltway might remain within a narrow legal travel exemption while their vehicle is in motion. But the moment they park, step onto a curb, or cross a sidewalk near a community center, they have effectively crossed a legal threshold, potentially facing serious criminal charges. The intensity of the pushback has been swift. Just days ago, the Department of Justice officially filed a lawsuit against Montgomery County, arguing that the ordinance is fundamentally at odds with the Supreme Court's precedent set in the landmark Wolford v. Lopez decision.
Our job is to try to protect people, and gun legislation is important in accomplishing that. And I would rather fight and then surrender when I have to surrender if there's a court decision than to prematurely surrender and put people more at risk than they need to be put at risk.
Federal officials have characterized the county's move as an infringement that makes it practically impossible for citizens to exercise their right to bear arms in the course of their daily routines. Assistant Attorney General Harmeet K. Dillon and the Civil Rights Division have made it clear that local governments cannot simply ban the presence of firearms in public places where people routinely go about their lives. By creating an arbitrary halo effect around thousands of locations, the county has allegedly created a de facto ban that ignores the reality of how citizens navigate their communities.
Back in the old days, they had an armory, and if you had to get guns, everybody went to the armory and got their guns out of the armory. We've gone way far in the other direction, away from rationality. And, we've got an irrational president, we've got an irrational Congress. We're just not going to surrender. If we get to a legal point and we lose in court, we lose in court. But I'm not going to surrender protections for people just because we're dealing with folks who are irrational.
The conflict has also drawn in religious institutions, which have emerged as some of the most vocal opponents of the new code. The Silver Spring Jewish Center, for example, recently filed its own lawsuit, arguing that the prohibition on carrying firearms near places of worship is not only a violation of the Second Amendment, but a direct affront to the First Amendment's free exercise clause. For this congregation, and others like it, the security of their members against rising threats, including anti-Semitic attacks, is viewed as a moral and religious obligation. They argue that the county's law strips them of the ability to provide for their own communal safety, turning a government ordinance into an intrusion upon their internal autonomy and their fundamental belief that they must be capable of defending themselves and their fellow congregants.
The rabbi I met with tonight is a plaintiff in one of them, and in it he argues that the county is violating his Second and his First Amendment rights, and also that it's prohibiting Jewish congregants from protecting themselves amid a serious rise in anti-Semitism.
The local government, however, defends these measures as necessary steps toward public safety. County officials maintain that their actions are designed to comply with recent Maryland Supreme Court rulings, which provided a specific framework for what types of locations could be declared sensitive, by removing hospitals and child care centers, which are already covered by state-level prohibitions, and focusing on the remaining categories of public assembly. The county believes it is operating well within its legal authority. They argue that they are simply tightening language and closing loopholes to reduce gun violence, suggesting that their goal is to keep these specific high-traffic areas free of firearms to minimize the chance of accidental escalations or violence in crowded spaces. Yet critics and civil rights organizations, most notably Maryland Shall Issue, point out that these measures do absolutely nothing to deter those who are already committed to breaking the law. A criminal planning a robbery or an act of violence is by definition indifferent to a municipal sign or a map indicating a 100-yard exclusion zone. The burden of the law falls entirely upon the person who has gone through the process of obtaining a state-issued concealed carry permit, completed the required 16 hours of firearm safety training, and passed rigorous background checks. The law essentially dictates that these individuals, who are already vetted and authorized by the state, must disarm themselves the moment they step into a public sphere. This clash has left many residents in a state of deep confusion. The legal situation is further muddied by years of court battles, even as the county claims victory in certain legal skirmishes, such as when they successfully fended off an initial request for a temporary restraining order in federal court. The overarching questions of preemption and constitutionality remain unresolved. The case has moved through various stages of the Maryland judicial system, with arguments reaching the Maryland Supreme Court, and now, it appears, the federal level. For the average citizen in Montgomery County, the reality is a constant, shifting uncertainty. They are left to wonder if they stop for coffee, visit a park, or walk their children to school. Are they carrying their firearm in a way that risks their freedom? The ongoing drama in Montgomery County serves as a microcosm for the larger nationwide debate over where the boundaries of the Second Amendment lie in the modern era. As municipalities across the country test the limits of local ordinances in the wake of shifting Supreme Court guidance, residents find themselves caught in the middle. It is a debate about the balance between public order and personal liberty, between the government's role in creating safety zones and the individual's right to self-preservation. While the lawyers argue in courtrooms and the politicians issue press releases, the people on the ground are forced to navigate a complex overlapping web of zones that change the very nature of what it means to be a law-abiding citizen. As the litigation proceeds, the eyes of constitutional scholars and gun rights advocates across the nation remain fixed on this corner of Maryland. If the federal lawsuit succeeds in proving that the county's regulations are an unconstitutional burden on the daily exercise of a fundamental right, it could set a massive precedent that forces cities across the country to rewrite their local ordinances. If, on the other hand, the county's approach survives judicial scrutiny, it could provide a roadmap for other jurisdictions to create similar zones, potentially altering the landscape of firearm possession for millions of Americans. It is a legal tug-of-war that is far from over, with the potential to redefine the relationship between local government power and individual constitutional rights for years to come. What remains clear is that the current situation is unsustainable for many. Residents are speaking out in public hearings, describing how the law makes them feel vulnerable and unfairly targeted, while others express relief that their local government is taking a stand against the prevalence of guns in everyday spaces. The tension is palpable, turning even simple community activities into flashpoints for broader societal debates. Whether this ends in a total repeal of the exclusion zones, a compromise that leaves the halos in place but clarifies the legal risks, or a prolonged series of appeals that keep the law in a state of suspended animation, the residents of Montgomery County are currently living in the crosshairs of a national constitutional crisis. Every day that the law remains in effect, the questions multiply. How do you clearly mark a 100-yard zone in a dense urban environment? Why are certain locations treated differently? How does a citizen confirm they aren't committing a crime just by existing in a public space? These are not just technical questions, they are the fundamental questions of a society trying to figure out how to reconcile widely differing views on rights and safety. The outcome of the litigation, from the synagogue's plea to the Department of Justice's formal complaint, will define the future of local gun control measures. For now, the maps are drawn, the lawsuits are filed, and the residents wait to see how the courts will decide the limits of their rights in their own backyards. The story of this legislation is a reminder that the law is not a static object. It is a living, breathing, and often contentious construct that can change overnight. For the gun owner in Maryland, the current climate is one of extreme caution. Staying informed, understanding the nuances of the latest court filings, and recognizing the risk of unintended consequences has become a part of daily life. It is a high-stakes environment where the difference between being a responsible, protected citizen and a person facing legal ruin can be as small as 100 yards. As the legal battle unfolds, it is the ordinary people on the ground who are left to hold the line, waiting for the clarity that only the final word from the highest courts can provide. That's it for today, folks. See you in the next video.